thank you for joining the webinar of, basically the title of this webinar, as you all know, is, the bombshell lawsuit that could change the industry forever. And I think certainly we're seeing this is where it's at, and this could not be a more timely and a more important topic to talk about. I'm Audrey Whittington. I'm the VP of Sales and Head of Strategic Partnerships at Local Logic, and have been sort of generically hosting these master classes. Before I introduce our panelists, I do want to say that I really love these master classes. Our head of marketing, Max, and I came up with them really to not have them be topics about why you should use Local Logic. We do believe Local Logic has a role in this, but generically speaking, this is supposed to be about what is happening in the industry, why it matters. And we appreciate that you guys keep coming back and recognizing this isn't just a sales pitch, that we really are trying to kind of talk about what matters in the industry once a month. So we appreciate your attendance and kind of keeping an eye on these and joining. Introductions, and then I'll pass it off to Lisa. James Dwiggins is the CEO of NextHome and has really been at the front of this topic because he has been caring about it for a really long time. So we really appreciate him joining. This actually was born out of a conversation of him and I just chatting, and I was thinking, well, we should all be talking about this. And he's like, well, we are. Now you need to. And Lisa Piccardo is the VP of Brokerage and Team Consulting at Team 3 at T360, that is working closely with James on this and is also very close to this issue. So I will pass it off to Lisa, keep an eye on time, and then just read off the questions, which we will, please note, we will not take the questions until the end. So it is all yours, Lisa.
Thanks. And James really has been one of the true key thought leaders in this. And we were joking yesterday that it's not just because he's the tallest person in the room. He's really passionate about it. But also, and just a plug for T360, Stefan Swanepoel and Jack Mueller for the Swanepoel Trends Report for 2023. We did a whole chapter on this topic exactly. And we recently did a statement to the industry. So,
which we will send out as a follow-up.
Yes.
To anybody that wants a copy of the recording, we will also send out your report because I think it's extremely well done.
Yeah, thanks so much. So James, why don't we start with some disclaimers? I'll let you go first.
Yeah, I mean, look, we're gonna talk pretty deeply about these suits. Technically, 3 of them we're going to cover, not just the Burnett suit in the title. I wanted just to be very clear about the things we're going to talk about today is based upon a lot of research. We are not your lawyers. We're not your insurance agents or your CPAs. So our discussions are our own opinions, but certainly backed by a lot of discussions. And in particularly my case, I've had a lot of conversations with lawyers who are both following this or actually involved in these cases to some degree or another. So I wanted to start out with that. Also, as we talk about these things, we're going to be really transparent with everybody. For those of you who do know me, I'm fairly direct about stuff. We don't sugarcoat things. So we're going to talk about the best case scenario, worst case scenario, which you'll want a cocktail for, and then the likely outcome of how these things will play out, which I think is important for everybody to know. We are rooting for NAR and the other defendants. Just to be clear, I've spoken with Katie Johnson many times. I think she's brilliant in her team. We're obviously, very much in favor of these cases going away. But as you'll hear me say quite a bit, I also think that hope is not a strategy, and the industry needs to start thinking about contingency plans in case things don't go the way that we want them to. So all that being said, there's our disclaimers. Lisa, take it.
Let me just add two others. If commissions come up at all commissions are negotiable. We know that, right? And then on a personal level, I'm a huge believer in the exclusive buyer representation. I've had my accredited buyer representation certification since 2008 or 9. So I think it's right for the consumer. So we'll talk a bit about that as well. So okay, let's dive in. So James, tell us, what are the lawsuits affecting the industry?
Yeah, so there's 3 current cases. Unfortunately, which is why we're doing this, there's only really 2 of them that are typically talked about. And then all of a sudden, everyone realized recently that there was a 3rd, which ironically was actually one of the first. So you have 3 individual class action cases that are moving through the courts currently today. You have Nosalek versus MLS Property Info Network, which you've seen in the headlines recently based upon the settlement that MLS PIN has done. We'll cover that in a little bit. You have Burnett and Sitzer, or Burnett Sitzer versus NAR, as well as several other defendants, which has a preliminary trial date of October 16th. It's coming up. This is a very concerning case. Obviously, in the title of our of our webinar. And then you have the really big one, the one that's the scariest out of the three, which is Moehrl versus NER, as well as several other defendants. So these are the three cases that are currently working through the courts. I'm going to cover this a little high level. I don't want to get like too far into the weeds on this just to not confuse everybody, but they're all somewhat based upon the same premise. So I'll start with Nosalek first. There are some differences between these cases that I think is important for people to hear as you're learning about these individual cases. So in Nosalek's case, this was filed in December of 2020. And essentially it's alleging that MLS PIN, as well as several other defendants, which includes essentially Anywhere, HSF affiliates, Remax, and Keller Williams. Essentially, the claims that they're making is that that the defendants are conspiring to inflate commissions by requiring sellers to make a blanket, unilateral, effectively non-negotiable offer of buyer broker compensation. Okay, I'm going to simplify that. Essentially, what they're saying is that because the MLS is set up in such a way where if you put a property in the MLS, you have to offer compensation to the buyer broker agent. There's a conspiracy that's occurring to prop up commissions amongst the industry. What is different about this particular case, which I think is important for people to know, is that MLS PIN is not an NER governed MLS, which is why NER is not a defendant in this particular case. Whereas in the other two cases, you'll see NER as actual defendants in these cases because they are NER governed MLSs. In other words, the governance of the MLS is controlled by the National Association of Realtors, the rules and policies that are put in place. So I wanted to separate that because what's interesting about this is they weren't named in it, but if you look at the case itself, they're still called a co-conspirator in the case. So they're kind of like saying that we might come after you later at some point in time, but they're not directly named currently now in this particular case. So this particular case has been moving through the courts, and recently MLS PIN had settled, or it basically put in a settlement offer, which is in preliminary review right now. It's not actually fully executed with the plaintiffs for $3 million. So this is just MLS PIN. What's interesting about this is this particular case, they are not settling with the other defendants. So Remax, Keller, and others are still on their own to defend this. And it's a little bit controversial because essentially MLS PIN is saying, we're going to give you $3 million. By the way, plaintiff had access to their books so they could see essentially the financials of MLS PIN and agreed to the settlement amount. But what's essentially happening here to some degree is this settlement money is essentially helping plaintiffs continue with their case to a degree. Now, some of that money goes to the actual plaintiffs. There's a bunch of things to pay some lawyer bills and stuff along the way, but essentially they're settling without the other defendants in the process. So the other defendants are on their own still. What's also important to note as I go through this, these same defendants have two other class action suits against them. It is a very significant problem for these companies based upon the amount of damages that are essentially being pursued. These are antitrust claims, all of them. So these are claims essentially at the federal level. They're very serious claims. Federal claims like this can also have treble damages. What that means is whatever the actual amount is can be multiplied times 3 for the total amount of damages that can occur. We're not talking millions of dollars with these cases. Just for clarity, we're talking billions of dollars for these cases. And as I go through this, they're very serious things that we're dealing with here as an industry. What's also happened, and then we'll move to the next one here because they're all kind of similar and we'll start moving into outcomes, but is MLS PIN has agreed to essentially remove that rule of buyer broker cooperation in the MLS being required. They went to optional. And this is also an interesting talking point because what that means is essentially the seller's agent no longer has to put in cooperation in the MLS. Technically speaking, based upon the policies of how all of these MLSs were offering, you could put technically a penny in there. I think $1 was the minimum amount that you could put in there for cooperation.
You had to put something.
You had to put something in there. Now it's optional. We have a use case to follow with this. So the Northwest MLS had initiated the same policy because, again, they're not an NER governed MLS last year in October. And what's happened is the outcome of making this optional is honestly not a whole lot. You haven't seen any significant change in essentially cooperation in the MLS. There's been small amounts of change. I've heard numbers around 3% change in actual, cooperation, but overall, it hasn't had much of an impact on the process. So the comment I want to make here is we have a use case of almost a year of this policy being in place in the Northwest MLS, and it hasn't really affected much. So I don't see this as some big, massive thing to make it optional in the MLS. And frankly, as we saw last week, Bright MLS made this move, which is what's interesting about that particular move is that they are an NAR governed MLS and technically are defying, being real technical here, but they're defying the rules of what is supposed to be done there. My opinion, again, my own, is I think you will see this happen almost in all MLSs because they're trying to limit liability as quickly as possible. This particular component is one of the key pieces of why these cases are being filed. And I'm going to explain this conspiracy that they're claiming in just a second. But if they're looking at it specifically as if you're asking a seller to pay not only the seller's agent's commission, but also the buyer's agent's commission, which in these particular examples, 40% of the time are the very same defendants representing the buyer, you're thereby guaranteeing, essentially propping up compensation. There are a lot of, and I'll move to the next one here in a second, Lisa. There are a lot of players involved in this process. And if you want to get really deep into this, there's two really interesting Washington think tanks that write a lot of papers on our industry. So you have the Consumer Federation of America. Essentially, they're all about going after monopolies or things that are anti-consumer in their mind. They've written several papers on how they believe, candidly, quietly misguided in my opinion, but they believe that the way we have the industry structure does not benefit the consumer, and that by changing these rules, all of the essentially commissions will come down. The second is the American Antitrust Institute, and their job is to essentially bring to light companies that are doing the same thing where they think it's anti-consumer or a monopoly, and they help the Department of Justice. They're a think tank that helps influence Washington politics and where entities like the FTC and the DOJ focus their attention. So there's a lot of moving parts in this particular piece. I'll stop there, Lisa, if you have any questions.
Yeah, I just want to mention the Bright. I mean, the Bright was a big eye opener, right? Bright MLS, 100,000 members, suddenly said, you don't have to put anything in for buyer agent compensation. I had some agent friends visiting recently. They're like, that's crazy. Like, what happens,
Yeah. Again, I think people miss the point, and this is important. And we're going to show this, and I'm sure legal counsel for defendants are, it's like, okay, we went from $1 to zero.
Right.
Like it wasn't, commissions have always been negotiable. Okay.
Right.
It's always been an option. And if you look at it, there are lots of companies that do different commission models and you hear about them. So it's not, this isn't some new thing. We're moving from in Brian's case, CEO of Bright MLS, he's like, we went from $1 to zero. Like it's not, it's in my opinion, a strategic move to essentially remove this piece that's being used. Right? Yeah, this liability, which is why I say that, all MLSs will follow suit. If I would be surprised if NAR doesn't allow this change to occur. Now they're a defendant, so they're not going to want to do things essentially that might, not help their case. But I would be surprised if NAR enforced any of these rules on MLSs. Let's put it that way. So, yeah. All right. You want me to go to the second one?
Yeah. And I want to hear why you think Mueller's the worst.
So I'm going to go to Burnett first, and then I'm going to go to Mueller. So Burnett is centered around the same process. Essentially, you have plaintiffs got together. They're saying that, the seller side or the plaintiffs, they're saying that they had to pay money that they didn't need to pay. They got together, filed a class action claim. They're saying that, buyer broker cooperation or compensation in the MLS is hurting sellers. This is centered around Missouri. So this particular case is focused only in the state of Missouri during essentially, I believe, a 4-year period of time. What's unique about this particular case is it's the first to go to trial, and it goes to trial in October of this year. So what they're asking for, though, is, damages. And this is where I'll get into the damages portion because it's kind of relevant to all of them. Plaintiffs' counsel is using the theory, well, it's not really theory, the fact that different countries sell real estate different ways and the compensation methods are different. They're not saying that agents representing buyers shouldn't be paid a commission or type of compensation, whichever way they want to do it. What they're saying is that based upon the way the rules set up, it's propping them up higher than they need to be. So they're using a lot of things like the UK as an example, where
1%.
Essentially compensation is around 1.5% less than what it is here in the United States. The theory is that they're basically explaining that the reason why, again, why I think this is so misguided, the reason why housing is too expensive and all of us in real estate are about to like roll our eyes is because people are paying too much in commissions. I'm like, no, you idiots, it's bad housing policy, but we'll get into that in a different way. So, but they see that as like one of the main things as to why people can't afford housing. So they're really advocating from the consumer's perspective. It's a double-edged sword. I think lack of buyer representation is an absolutely horrible mistake for people when they make an investment. So there's a rub both ways here. But essentially, that's what they're doing. They're looking at it from, and this is why I'm saying all of this. You take a 4-year period of time in Moehrl's case, for example, and they're saying everybody who bought a house or essentially sold a house in this particular time frame didn't potentially have to pay X amount of money in compensation on the other side of the deal. Okay. And so you take those numbers.
The proceeds should have been higher because of that, right? Correct.
You take this number and you multiply it times every person that bought or sold a house, and the cases are somewhat different depending upon the plaintiffs here, but same concept. Over a 4-year period, we're not talking a small amount of money here. We're talking billions of dollars here. And then those damages, because it's an antitrust claim, is treble damages. So it's that times 3. Now you're going to hear numbers all over the place from, I've got friends who are very extreme on this saying it's, 30 to 60 billion dollars. You've got people saying it's a couple $1 billion. Doesn't really matter. It's with a B, and it is severe if this ends up going this particular way. Now, a couple other things with Burnett, which is interesting. So right now the trial's set for the 16th of October. This is a really important thing I'm going to talk about right now. This is the thing that our industry needs to hear because there is not the most accurate information being submitted to the industry. This trial date is set for October 16th, currently today. There is a backup date for February if there's a conflict that can occur, but all things are pointing to October as the trial date. This is federal court. One of the things that this defendant or this plaintiff is asking for is an injunction on buyer broker cooperation in the MLS, not to make it optional, an outright injunction on it, period. Just to be clear, because you can't offer it at all. And this federal judge can, if they want to, take that injunction and not only enact it in Missouri, but because it's federal court, they could technically enact it federally. You've seen this in politics where, you've seen.
They could just say NAR has to restrict this period.
Correct.
What do you think
Yes.
the chances of that
It
are?
is federal court. It is a federal judge. They can enact it federally if they wanted to. This would be a very extreme version of this. I'm not saying this is going to happen, but it is a potential outcome. Why I'm sharing that with people is that you're hearing these things that this is going to play out over 5 to 7 years. That is true. The damages portion of it will take time to play out. No matter who wins or loses in these trials, they're going to get appealed. The lawyers involved in these cases are massive law firms. These are not ambulance chasing lawyers. These are big firms that have sued companies like US Bank Corp and Raytheon. Like, we're talking major law firms. They don't take cases unless they're going to win. They just don't. This is a difference between, like, everyone's like, whatever. And I'm like, no. This is not a small time law firm. None of them are small time law firms. So this is going to play out, but what is not being stated is if the judge decides to enact that injunction can be upheld during the appeals process. So in other words, it might take 5 years for the damages portion to play out, but what if cooperation in the MLS is not allowed at all? It is a potential outcome. What I'm going to talk about towards the end of this is what if the Federal Trade Commission wants to come in and do it, which I'll explain some really crazy things about that. So there is very significant concerns, and people should be thinking very seriously about how you are preparing your organizations for an outcome if it did happen. Again, we are rooting for NAR and defendants. We want them to win these cases. I think that a lot of the claims in these cases are, not accurate. I don't think there's this big conspiracy going on. We know enough about this industry to know that we don't communicate as much as we probably should. So there's not some big conspiracy here, but there are potential outcomes that could be, depending upon what it is, pretty catastrophic for the industry. Questions on that before I go to Moehrl?
No, I think we should talk. Well, go ahead. We'll go into Moehrl and then we'll talk about how to prepare.
Moehrl is basically everything I just talked about. It's just much, much larger. It's covering a much larger portion of the US for the defendants. And so the damages are significant in this particular case.
And they're also seeking a permanent injunction, right? Stopping from sellers paying buyer broker.
That is correct. That is correct.
Mm-hmm.
I don't need to go. The defendants are basically the same as Burnett. It's just not Missouri. It's basically 11 different states. I think I'm correct on that. It doesn't matter. It's massive market share they're covering. There's a lot of MLSs and people involved in it. It is a significant problem, and which is why I think you're starting to see the industry moving in a direction of essentially limiting liability and starting to think more clearly about how do we set up contingency plans. I will say this one more time: hope is not a strategy. Do not listen to lawyers telling you that this isn't a big deal. They're wrong. They haven't studied it. They haven't spent enough time on it. These are big deals. It doesn't mean that we're not going to fight it, the industry, tooth and nail to win, but you also need to start planning for what if these things actually occur. So I'm going to end it with this, and I think this is extraordinarily important so everybody understands what this is about so that you can kind of see plaintiff's case in a nutshell. So I'm going to give you 5 things that you need to be aware of and what plaintiff's going to use in these arguments. First, these have nothing to do with the Department of Justice. I want everybody to understand this. Everyone's getting this mixed up. The DOJ, these are civil cases. The DOJ is a completely separate thing I'll talk about in a minute. That has nothing to do with these cases. They're watching them, but they are not involved in these cases. These are civil cases where you're going in front of a jury. I want to explain why this is important. Of your peers, people that have bought a house, want to buy a house, maybe a renter, and plaintiff is going to use this to their advantage. They're going to show people that you bought a house and you overpaid. Well, I hate to say it, but Americans are greedy. We all are. If there's a way for us to get $10,000, $15,000 back, times are tough right now. They're probably going to think about that. I wish they were impartial, but let's be honest. Number 2, if you're a renter, they're going to be like, and you can't buy a house because commissions are too high. This is what plaintiff's going to use in the process. But here are the 5 things you need to know. Number 1 is in most MLSs, NAR governs the policies of those MLSs. So here's the conspiracy. So everybody sees it. This is what they're going to say. NAR governs these policies, which is why they're a defendant in 2 of the 3 cases. Large brokers, defendants, Keller Williams, Anywhere, HSF, Remax, etc., have involvement in NAR and these decision-making processes, which is true. They have people on committees. This is how NAR works. You have the buyer-broker compensation policy, where if you put a listing in the MLS, you have to offer cooperation on the other side. This is the catalyst to where this whole thing went south, in my opinion, is the clear cooperation policy. Why I think this is an important part of what plaintiff will use in their case is you've always had this cooperation policy in the MLS. But when the clear cooperation policy came into play, by the way, this is totally unintended consequences of decisions here. I'm not saying there's any maliciousness to this. But when you're basically saying that if you're a member of the MLS and you take a listing and you can't have it as a pocket listing, you must put it in the MLS within 24 hours. Well, now you're basically saying all these properties that didn't want to be part of the MLS for whatever reason, let's not get into that nonsense, but they didn't want to be part of the MLS are now being forced to be on the MLS, thereby guaranteeing cooperation on the other side of the deal. And then the fifth thing and the most important part is our commission rates are higher than almost any other developed country on the planet. So you're going to see it laid out just like that in a much better fashion than I just did, but I'm simplifying for you. That is going to be a very hard thing for us to overcome, which is why I'm going to lead into the outcomes of these things now, but I'll stop for questions from you before I dive in.
I think we'll dive into the outcomes and then I really want to spend time on what they can do so that everybody can leave here terrified.
I got that too. Yeah, I want to preface this, that the sky is not falling. I want to be very clear about this. There is a very clear path on how this ends up. I run a very large real estate company. I'm telling you, this guy's not falling. We will adapt. There will be changes.
Correct.
I honestly, and I'm fine with being on record for this, I see no problem with having it optional in the MLS. I don't. I don't think it's going to change much of anything. And candidly, there's always going to be people that try to find unique ways to market properties and do things. My response is get better at your job. We need to do it anyway as an industry. So now I'll go into the outcomes. Best outcome, quite simply, NAR and defendants win. Woo! We win, we move on. The reality is, this is the best outcome. And I will say that, MLS, this buyer broker cooperation or compensation part in the MLS becomes optional. I think that is a guaranteed thing. You're seeing that movement that's going to happen anyway. That certainly stops a lot of this conspiracy part because it removes this requirement from the MLS. So in my opinion, that is the best outcome. I do not think that is the outcome we are going to see. Nothing that I'm seeing and nobody I'm talking to thinks that is the result, which is why you're starting to see people settle in these cases. So, all right, want to go to the worst outcome? And then I'll go to likely.
Yeah.
So it's 10:30 here. For those of you on the East Coast, grab a beer or a cocktail. Worst outcome is we lose and lose badly. The damages that I mentioned is billions of dollars. I want to be very clear about this. The industry doesn't have this kind of money. We're in the brokerage business and most of us are broke right now. So the market is not fun for anybody at this point. The balance sheets for even the defendants have nowhere near this kind of capital. It's bad because you take the damages and then the judge can do 3 times that for treble damages if he or she wants. I think cooperation worst outcome is outright banned in the MLS. I'm not convinced that will be it, by the way. I'll share that, but that is a potential outcome that could occur from this. Here's the crappy part. You'll see this happen as early as October. If we lose this case in October, this will occur. You will see copycat lawsuits filed across the US. And what that means is what happens is they just laid out a case in Missouri. And so essentially the rest of the US is opened up for a similar case. And then you will see ambulance chasing lawyers jump in and everybody files suit. And unfortunately, this will be really bad. Everyone gets named. It's going to be associations and MLSs and brokerages. Agents don't hold fiduciary, the brokerage does. So they're not going to be anything to do with the agents, but brokerages do. And it would be pretty painful. I have done the preliminary research on this topic. So you need to talk to your insurance broker about it. But unfortunately, my research shows that if they're antitrust claims, which is what these are, your insurance carriers will not cover you for either legal defense or damages in these cases. So you would be on your own for defending it. And the outcome of it would be pretty severe. Like, do the math on it, but if nobody can defend these cases, you see bankruptcy occur across the industry. Now, I want to be very clear about my statement. That is not going to happen because there are no law firms in the United States that want to not make money. Like, it's just not an outcome. Like, you don't just try to bankrupt an entire industry. It just is not the reality of it. So when people talk about that, they're being completely naive to how American businesses work. We're capitalists. So they want an outcome where their clients and they make money. So, I think that it's important to know that when you hear these things, some of what I said is a potential outcome. It is a very unlikely outcome for how this will go. That's not how our system and our courts work, and et cetera. So let's jump into the likely outcome. This is my opinions. I hope I am wrong for everybody listening. I'm trying to be pragmatic and real about this based upon conversations I'm having with lots of industry experts and lawyers who read this stuff and look at this stuff and kind of have been through these things and say this is likely an outcome. The outcome is, I think that NAR and defendants will settle these cases. It is the best outcome for the industry. What does that look like? Well, again, this is a general consensus. You need to take all the chips off the table. And what I mean by that is you need to get everybody. It sounds really weird, but if you remember seeing the movie like Aaron Brockovich, like you need to get as many people into the class as possible. What that means is you bring everybody in that time frame for these suits into the actual lawsuit. I'm really simplifying here, but if it's 50 plaintiffs, you bring it in, it's every homeowner who bought a house during this time frame. You try to get everybody in. And you come up with a settlement amount. I've heard numbers thrown around of a couple $2 billion. I'm not going to be the person that does the math on this, but the idea is if the industry could afford $1 billion, you say, great, we'll do $2 billion to get as many people into the class as humanly possible. And it's paid out over a period of time. And then essentially defendants, NAR, and every single person who's associated with NAR is essentially assessed money to come up with this amount. And you settle the case. It's done. It's over. The lawsuits are gone, and essentially we move forward. I think that a part of this is for certain cooperation. The MLS is optional. Guaranteed that's going to happen. 50% chance it's outright banned. I'm not convinced it will go there. It just doesn't. That's not to me. That seems like a stretch. Allowing people the options to make choices. Maybe there's disclosures that are signed up front when you're sitting down with a seller that explains these things in more detail. I think there's some changes that can occur. I don't think the courts need to go as far as just saying no, because the MLS works. It's a great place to share information. That's why I actually agree with the clear cooperation policy. We can talk about that another time. So one of the fastest things is NAR enacts through their MLS policy and code of ethics that require buyer brokers to have a signed buyer broker agreement when they show a property in the MLS. I want to explain this. We need to get it, which I believe, Lisa, if I'm correct, it's 12 states currently that require buyer broker agreements now. I remember looking at the sheet we were working off of, but there's a lot of states that already require this. I think if you moved it to this way where if you're going to show a property that's in the MLS, you need, before you do so, the buyer needs to sign a buyer broker agreement. That levels the playing field, but it also does two things to help the consumer. One is it establishes fiduciary, which our industry is very vague about in many ways. And number two is it also helps the seller not have a bunch of looky-loos coming in their property. It's a verified buyer working with
serious buyers.
Yeah. Like there's no, in my opinion, there's no downside to this. So
well, and it depends. And, one of the challenges is a lot of companies that have a lot of listings and the state doesn't allow dual agency, or they have to do a designated agency, or move to transaction broker. So
I agree.
There's a lot of
and it goes to safety.
there.
Sorry, I had to jump in because I want to kind of note time here. We want to have some time for questions.
We want to get to
I'm basically done here. So in a minute. So
I think we're going to how to prepare. So
so I think there's that. I'll move to the prepare part so we can go to conversation. I do think there's a 50% chance clear cooperation policy is rescinded. Although I don't agree with that decision. I think that if you remove this requirement in the MLS, the clear cooperation policy is actually good for sellers. I'll be bold about this. I hate dual agency. I think it's an absolute atrocity to sellers. I have no problem saying that. You cannot represent a buyer and seller and not have bias. To be clear, I have no problem with another agent and a brokerage representing the other party, but I do not believe that an agent should represent both. That might get outright banned as well across the US. Let's move into a couple of things here, and we'll talk about what people
how to prepare.
Yeah. So three things NAR needs to do immediately. Number one is I think that depending upon timing, they should look at making it easier for MLSs to rescind this buyer broker cooperation policy in the MLS. I know they're in defense and they have to watch that stuff, but Bright's doing everybody else's. There needs to be some thought around that. As I mentioned, that mandatory policy, I think they need to look at that. Certainly there's going to be idiosyncrasies by state, but I think that levels the playing field so that the industry, a buyer has to work with an agent, or if they're going to sign it and everybody has to do the same thing. I think is smart. And the most important part is they need to be mobilizing lobbying resources so that essentially the buyer's agent's compensation could be financed in the loan. And they need to work through a lot of those details to do that without getting too specific. But there are some loans you can't do that with, and they need to work on those things now so that if a buyer, we all know first-time home buyers cannot afford to pay an agent that money. Like it's not possible. So there needs to be an option for them to be able to finance that. MLSs, again, make it optional. You saw Bright do it. I'm sure everybody else is. If you're not, you should. You're limiting your liability if you do that. It starts to put that you're essentially saying that's not something that a plaintiff can use going forward any further. They should prepare for commission pressure and attrition. You're going to see pressure on buy side compensation. You're just going to, and they need to think about consolidating further. We've done a good job of that, but we're still at 400 and something that needs to get down a lot further. And then my final comment for MLS is you need to think beyond just being a repository of listing data. How do you work better with the industry on driving innovation, adding additional data sources, just really rethinking the MLS as a data structure and what it does and how it helps brokerages and agents innovate further. There are, and I can speak for at least many people on this line, MLSs are too many times an inhibitor to growth and innovation in this industry. It is still a problem. It's getting better, but it is still a significant issue, and it is not advantageous to the membership based upon the way that this industry is moving. Brokerages.
Let's talk about brokerages and agents.
Yep. Brokerages. And this is what we're doing. So I'm just giving you like our roadmap. We are working with our offices right now to require signed buyer broker agreements at the beginning of their agents' engagement with buyers. Get everybody to read them. Most states don't use them. You all have them, or I'm sure they do. And you need to at least read them and start getting used to talking about them and getting very good at explaining what it is that you do for buyers. You need to get very clear on your training material. And by the way, I'm going to plug just for a second, but T3 is doing a great job of coming up with a program. I've seen it and we're working with them on some of this. So again, a little bit of plug here, but there's some really great stuff they can do to help you analyze your marketing material, change things around, increase your value proposition on the buy side, do an assessment, teach you how to overcome these objections. So talk to Lisa and her team, but you need to be thinking about this internally right now. How do you?
And then one other thing on that, the buyer, I think a lot of those buyer forms need to be updated. I just saw one of the states recently has a proposed updated version that really spells out the compensation, and it's well done. So
the two others on brokers, and I'll come to agents and I'll make sure we have time for questions. These are going to be really controversial statements, but number one is you need to think about, from a brokerage perspective, cutting down your overhead and your expenses. I know we've been doing that based upon market conditions, but you need to think about it further. The reason I say that is there is no scenario, even in the best scenario, where we won't start to feel some pressure on buy side compensation. Depending upon the severity of these cases, it will be less or severe, and you need to start planning around that. That leads me into the second controversial statement, is that you need to start thinking about different ways and compensation models with your agents. Less traditional, think about how you can structure different ways of compensation. And we're going to talk about this in this next piece, because I think this is a reality of what we're going to face. And then we'll go to agents, and then we'll leave it for questions. As I mentioned, agents, you need to start using these buyer broker agreements. I know it's scary. Get over it. Like, start figuring it out. You do it on listing appointments, start doing it on buyer appointments.
And there's a lot of benefits to you as the agent, right? Your time is valuable. And I think that that's the big miss. Like, agents aren't good at selling their value on the buy side at all.
They're not.
Like, another thing is buyer broker presentations, right? I mean, buyer presentations are so good, and you should have all of this information in there.
Yeah,
you know,
that's what we're looking at. That's what we're
yeah,
headed
so
with it. Yeah, for
everything,
sure.
you know, why you, all of the benefits. The other
Which
thing,
no one does and no one
just a plug
uses
for our
them.
host, they have neighborhood profiles. Local Logic provides, that should also be in. It should be why your value, all these pieces should be in your buyer presentation.
Sit down and think about if you had to come up with, you know, compensation to the buyer's agent that you had to pay out of your pocket. What would you want to see from the buyer's agent to justify that compensation they're asking for? And if you can't convince yourself, then keep figuring out how to do it, because if you can't convince yourself, you're not going to convince somebody else. By the way, one comment, super important. For those of you who are like trying to figure out your value, just think about how much time you spent working with buyers in 2021. You do way more work with a buyer than you do with a seller. So just start psychologically thinking about the fact that, damn it, I am worth this. Like, I can't spend 100 hours working with a buyer and like not be compensated. So just really think about that. The two final things, and then I'll shut up, is you need to start thinking about different compensation methods based upon a buyer's needs. And to be frank with you, percentage, hourly, flat, some combination of, I don't care what it is. Maybe some of you do that already as it is, fine. But like, you need to be thinking about these different options, because you're going to see some of this pop up. It's just it's going to happen. So,
Okay, I'm going to cut in because I really we have 15 minutes left, and I'm sorry, but we have to go to questions. I will throw one thing in, and again, we try not to show for Local Logic, but I will say one thing about our view on this. We're coming out with a product. We already, of course, have all the data outside the four walls, which is what we do, but we are releasing a product, and I know James has been really helping us with, called maybe final title location assessment report. It's basically, right, James, Carfax for the neighborhood.
yeah, I love it. The Carfax for the neighborhood. Yeah.
I know. I have to give you credit for that.
I want 10%.
Okay,
That's
you know, what will be. You only have 200 and some odd witnesses, but the reason we think it's important is exactly this: is that really people, you know, you can find a property on Zillow, let's face it, realtor.com, but you have to be the neighborhood expert. You have to explain everything that has to do with the property. And that is really where an agent comes into play, right? Is if I'm moving to the neighborhood, I might be able to find a property, but I really don't know about the rest of it. I don't know what happens when I walk outside. I don't know about the schools. I know agents are supposed about schools, but generically, I don't know what's nearby. I don't know where the grocery store is. I don't know the drive time. So that's our positioning on this. Is that we actually, when I first talked to James, I felt excited because I was like, well, great, we are actually coming out with products that will enhance what the buyer broker offers to the consumer. And now
one of the issues there is that I think some, you know, agents are worried about risk, and brokerages are worried about the risk, because it's high risk being a buyer agent, right?
Yeah.
So that provides them with some intel that they really need to know.
Yeah, look, I think the truth of it is in truth, having bought and sold many houses, there's no way I could have done it without an agent. You know, you just can't. And if you've done it at all the first time, you would never do it a second time. So let me go to some of the questions.
Please ignore some of these questions, because I can see some of these are my friends, like the review.
Well, not to worry. So I can curate. Some of them are statements. So no, we won't ask the first question of what you think on the Barbie movie. I understand. Okay. So one person asked, like, right off the bat, is this the US and Canada, or just the US? Do we believe this will move to Canada?
There's actually cases occurring in Canada right now that are similar in their regard, but there's also, they've had cases like this in the past. I'm not as familiar with the Canadian cases. I'm not going to dive into that, but there are similar cases in Canada currently today.
Okay. So another question we got asked was, Lisa, can you provide the 12 states, you know, that or James that mentioned that I think mandate buyer broker. To another question we got, and I thought this was interesting. This was both sort of a comment and a question. A lot of these are comments, so forgive me if I kind of scroll through. Somebody asked, like, if the law, if in the sort of in the states, like I think New York and parts of Pennsylvania, and I think I can't name all the states, where the lawyer is, you know, does the settlement and is really as much involved as the agent. Does that mitigate this in those states? And if the lawyer did more, the agent was still involved, what is the net effect for them? Because the lawyers are so much more involved in the transaction in that state. I thought that was sort of
not based upon the way these claims are faced. I'm not a lawyer. I'm just going to, the main premise of these cases is that the the compensation is being propped up based upon the structure of the MLS and defendants being involved in the policies of the MLS. I'm simplifying here, but it's those 5 things. So it doesn't matter who's essentially doing the, whether it's title, escrow, or lawyer that's handling it, that's really separate and apart from it. If anything, I'm not a lawyer, but maybe they could be a defendant in one of these other cases.
Okay. All right.
And I just, one of the questions in here that's come up a couple times too, is about the idea of like negotiating the buyer commission in the part of the deal.
That's the one I was just going to read.
2 or 3 questions.
Yeah,
certain states that is not allowed. Like you cannot have anything in the contract that is not party to the 2 people in the contract, the buyer and the seller. So, so I know where I came from, we used to put that into the contract sometimes, but now some of the states don't allow that.
Some of the states don't, and I'm going to speak for all of us here. We're not going to get into the minutia of every individual state. Right. You're going to have to go look that up. I can say that some states do. And so what happens in the cases that as an example, the buyer's agent writes in the purchase contract that the seller is responsible for paying the buyer's agent's compensation. Again, state by state, we have Lisa and T3 have done a fantastic job of organizing a chart, and they'll do this if you do this assessment with them, which everybody should. But it'll tell you where dual agency is allowed, whether sub-agency, like there's all these, our industry is so convoluted, but like there's a whole bunch of stuff by state, and they have a really good grasp on how it works by state. I would have you reach out to them. And
let me jump another question. Who has to approve the practice of allowing the buyer compensation to be financed? Fannie and Freddie, HUD? Because I know you mentioned that, you mentioned it to me separately as well.
Yes.
Okay, Fannie and Freddie and HUD, right? I mean, your answer, I personally thought that was the answer, but you're confirming, right? It would really be Fannie and Freddie. It's anybody really who underwrites the loan, in effect.
I mean, keep in mind, you're dealing with the secondary market, so the loan has to be sold. So you're talking about Fannie, Freddie, and HUD.
And here's an interesting question on that note. Do you see the possibility of first-time buyers, FHA, and other loan programs being allowed to finance buyer broker fees? I think you mentioned yes, so they have the guidance they need. And then experienced, quote unquote, buyers need to pay out of pocket, I
think it's going to be very dependent. Here, let me give you an example. If I was a listing agent in this potential new world, one of the very first things I'm going to do when I sit down with a seller, if I cannot offer compensation to the buy side agent, I'm going to say, there's about 100% chance that the person buying this house is going to be a first-time home buyer. They will not be able to pay compensation to their buyer's agent. It's very, very unlikely. You need to very strongly consider offering compensation in this particular deal. Where I'm going with this comment is it's going to change by market. When you're dealing with super high-end luxury market, like when someone's buying a $10 million house, it's going to be a weird statement. A lot of times people with that much money don't give a shit about like the commission because it's not about that. They have so much of it, but it may be that things are different in that market. It's why I said you need to be thinking about.
Yeah, it's going to be different.
It's going to be different. You need to have different compensation models, and it's going to change by market and where you're working, but you will absolutely, in my opinion, see that this model, despite what plaintiff and a lot of these organizations are saying, this isn't going to change from the first-time home buyer market. They cannot afford in this housing market to pay that kind of money out of pocket. They're not going to do it without representation. So it's either financed or the seller is still going to come up with that.
Okay, here's another interesting question on that note, and I've been kind of culling through. I think this is an interesting question. What prevents us from even going further to put the seller and the listing commission in the crosshairs? Once their exact wording was, once the MLS is busted up, then the sellers can just upload their own listing to Zillow, for example. And I think that's a fair question.
What was the question? What's stopping
in
that?
effect, what protects, like, if once we get rid of the buyer, the buyer broker compensation, right? What protects us really from going to an online, in effect, listing model? Why isn't the seller commission?
Well, I mean, you said it yourself, Audrey, like people still need an agent to represent them. And that's still happening all the time. I talked to a big producer recently in a luxury resort market, and, they want to buy a property from their neighbor and they're hiring her and paying a buyer broker fee to do it. Right. So that happens too.
I wholly disagree with people when they think that buyer representation is going to go away. I'm not saying that as a biased person who runs a big real estate company. Let me give you the economics of this. we live in the most expensive country. Inflation has been out of control. People can't afford much of anything when it comes to housing. You have to have 2 incomes to live in this country anymore. If you even have kids, which we have a whole birth gap problem going on, it's a whole different conversation. But you even have kids, who in the hell has the time to try and deal with all of this stuff? Even for those everybody here, you're welcome, by the way, that live outside of California. You can thank California for the massive contracts and disclosure documents that your buyer and seller have no idea what is in any of that. So as an example, when my mom just bought her house a few years ago, the disclosure package for that condo was 126 pages. I'm in real estate and I have no freaking idea what was in that. So I hired an agent to go through that. And why I want to make this point, she spent 6 hours reading that document to give me everything I needed to know. You get one thing wrong, and this, I've said this to the American Antitrust Institute. I was like, you decide to get rid of buyer representation. Here's what's going to happen. You're going to have so many lawsuits occurring because you have people that were unrepresented, that didn't understand what they were doing. You have sellers that weren't disclosing stuff, and an agent didn't catch it. And like, you will see so much litigation occur that it will be completely counterproductive to what we're trying to achieve. My point is California is making it harder, and you're welcome the rest of the US. So,
okay, I agree with that. I'm going to throw in the last question and then we've got to call it. And we might just have to do a second one because this is awfully robust. I'm going to combine these 2 questions. I do think like one of the questions was, right now there are no definitive ways for buyers agents to collect their fees outside of sort of their franchise or their broker. So that's concerning. And it does kind of dovetail into the second question of if clear cooperation goes away, right? Which I know you believe it, you support it, James. You were clear there, and you said you probably don't think it will.
I don't, because I think it's pro-consumer, to be clear. I don't think it will because it benefits the seller. That's not what the DOJ or the FTC want to do. Is they're trying to help the consumer. So
okay, so that addresses that one. But what are ways that if we go to these different models, that buyers agents can protect themselves for collecting their fees and things like that? I think that will land on that question.
Like that's the main thing. Like, and somebody commented in here that brokerages need to stop bringing on people just with a pulse. Like agents need to be trained, right? Like they need to understand. And I think that a lot of agents just don't understand that that they can't provide guidance and advice and all of this, like, the things that they're doing as a transaction broker, that they have to be a buyer agent, right? I mean, they have to really be trained on that. And then they have to be able to sell their value. Like, here's why you need me.
I'll end it controversial. I actually think when all of this is said and done, our industry will be better.
Yes.
I think you see a lot of attrition, and I love everybody in real estate. To be clear, I want everybody to have the same opportunity, but there's way too many damn realtors who don't know what they're doing.
And I'll tell you, and James, just to interrupt you for a second, one of the first things I asked James is I said to him when we were first talking privately, I said, why now? Like, why now? Like, why now? Why is this happening now? This policy's been in place for ages. Consumers have been paying both sides for forever. Why now?
It's because of the clear cooperation policy is why now. That's a whole conversation, but that's the catalyst to all of this actually occurring. I want to make sure that people, this isn't complicated. It just really isn't. We're going to work this stuff out. We're going to figure out how to have compensation financed. You need to be thinking about changing your business, but we also need to get really damn good at talking about what we do to people. And I'm so like, if you can't explain to you what you do for someone, then you shouldn't be in this business. Like, I know lots of agents that literally will not work with a buyer unless they sign a buyer broker agreement. The end. They're like, I've been doing this for 20 years. This is what I do. This is the amount of time it's going to take. They're very good at it. And that is what we all need to achieve to be. And it's not complicated. Sit down with people, your friends, and start laying things out and have an honest conversation. Ask them, would you pay me whatever in order to do this? And they're like, no. Okay. Go back to the drawing table until you can figure out how to get it to a point where they're like, wow, I didn't realize like you did all of that. And that seems like it's worth that value.
What's so telling? And we'll conclude, but what is so telling, if I'll have the last word if that's okay with you guys, but what is so telling is everybody that I know that's been in the industry forever, and I'm 25 years, my family's in real estate, I pay an agent. I pay an agent every single time. and you, James, are paying an agent, right? You know, we believe in the value. If anybody in this industry could probably do it on our own. If anybody could, we could, but we can't, and we acknowledge the value ourselves. And I think that that is so telling. There was one last comment about like, I'd be terrified if they asked about neighborhood information. Please find us. We could help you with that. We do believe we are working closely with James on sort of making sure that Local Logic is at the front of this as well, and providing the kind of information that sets you up for success as the local expert. Because at the end of the day, this really is going back to your value as the local expert. And it shouldn't have to be just within your street, that you only work your street, right? You have to be able to understand the community, and you have to give the person the value. Because I can tell you, you can go to the best portals, and I love all the portals, having come from the portal side, but they don't have everything, and they can't sell a buyer a house. They are a information repository. They are not a local expert. And that's a fact, Jack. So thank you, everybody, for joining us.
Thank you, Audrey, and thanks, James.
Really, really appreciate it. If we need to do another one or expand, we will. But I really appreciate everybody joining, and I hope they have a great day. Thank you, James. Thank you, Lisa.
Everybody. Appreciate it.
Okay, see you later.
Bye.